Howdy, I'm going to talk about how to end state-sanctioned murder. The examples of murder are too many to recount. A couple of more recent ones. Ahmaud Arbery was murdered while jogging. Prosecutors took action only in response to public outcry. In Minneapolis, the casually brutal murder of George Floyd by police officers was reported in multiple videos. An incredulous newscaster asked, how can it take 4 days for the prosecutor to bring charges? And then the charges are third-degree murder. These are state-sanctioned lynchings by white terrorists. And the legal basis of the state sanctioning is twofold. First, Police Bill of Rights. Second, state regulations for police use of force. I'll quote the Florida regulations first. They amount to a license to kill. 2005 Florida Code 776.05. The officer is justified in the use of any force, including lethal, in arresting felons fleeing to prevent the arrest from being defeated by such flight, and the officer reasonably believes that the fleeing felon has committed a crime involving the infliction or threatened infliction of serious physical harm to another person. Note here that the term felon is used presumptively. Police officer sees somebody he doesn't know or doesn't like, or who's running out for a jog, or who runs away from him. The officer is plausibly authorized to be judge, jury, and executioner. This tendency, this ability within the law to do these things is enhanced further by the fact that police training is to shoot to kill. In America, that's what we got. You fire your gun, empty the clip. And then to devalue human life further, many states, including Florida, of course, have stand-your-ground laws. They devalue human life. They give everyone a license to kill for momentary fear, whether justified or not. But back to the Police Bill of Rights. Those are passed by the state legislatures existent in 18 states, including Minnesota and Florida. They invert the rules of evidence. The defendant, who has committed some apparent crime and is a police officer, gets time off with pay and is not questioned regarding the crime until after the prosecutor's case is complete, and after the prosecutor has presented that case to the defendant and his lawyer. And after that, the defendant and lawyer have a time period to build a defense against that particular case. So that's pretty bad, because the prosecutor is not allowed to change his case in response to the obvious holes in many cases in the defendant's story to explain the case that was presented to him. The lack of initial interrogation is fundamental to getting police officers exonerated at trial. But the prosecutor frequently prevents them from even going to trial because, well, he is dependent on police officer testimony and the cases he brings in his jurisdiction. He is embedded in the system, and before the grand jury, which will determine if the case goes to trial, the prosecutor typically in police cases channels the defense attorney. Not surprisingly, indictments are infrequent and, of course, convictions quite rare. Witnesses, police officers who saw the crime committed, while they seldom or never rat out a fellow officer, they adhere to the thin blue line. They toe that line, even though it's a moral compromise, because if they tell the truth, if they testify truthfully against their partner, They know how to get away anyway. The system is set up to provide moral compromise, to require officers at risk of their career and their promotions to lie, because telling the truth would do no good. What do you do about all this? Well, I'm running for Congress to legislate, to make federal law. I take as a mandate that the rule of law conform to fundamental principles. The applicable principle here is that no organization should have the privilege nor face the moral dilemma of self-investigation. As an aside, constitutional checks and balances between judicial, legislative, and executive branches are intended to effect exactly this at the topmost level of our government. They have been sabotaged, but that's a different thread. What federal law is applicable to unsanctioning murder by police? Well, federal law would simply be to make a Leo-involved death or injury to be a federal crime, investigated and as warranted prosecuted at the federal level. Now, I've used the term law enforcement officer because it is more general than police officer. It encompasses also prison guards. That's significant in the abuses that our system encompasses. This law, federalization of the crime of police officers, negates the injustices of state BOR laws and also applies the Supreme Court Fourth and Eighth Amendment rulings to define police use of force uniformly. The police officers in that thin blue line, I've talked to those who don't want to be in that thin blue line. They would rather do what they joined the police force to do, which is serve and protect, and that is not consistent with having to compromise their integrity and not outing their comrades in arms. But with the federal prosecution, those officers will be wholly justified and will truthfully testify because they know the alternative will be prosecution of themselves. Independent federal investigators, probably the FBI and prosecutors, will impartially pursue justice. So, along with this, I will work for ancillary reforms that establish law enforcement as a profession, that requires national training standards to be established, 3-year training comparable to Norway as a good starting point, that training would be in a tuition-free public institution. All public education needs to be free. It would have competitive admission, and it would also feature a cost of living stipend because police who are retrained to meet new standards and new salary concepts will be needing to support their families as they do so. The professional salary will guarantee that there is competitive admissions and will be commensurate with the educational demands that a good police force requires. Thank you.